Thank you so much to Bill and Dean Sterling. It's great to be here back at Yale Div School. It feels like a lot of water under the bridge since I was last here, but it's really quite an honor to be invited to join you for this wonderful lecture. And I also just want to thank both Bill and Dean Sterling for their friendship and support and good counsel through the years. I really do, both when I was at the White House and outside of the White House. They've become good friends, and I'm grateful for that friendship. And also want to thank Lynn Haverstad. I'm not sure she's here, but she ran around like crazy to get all these details done. So thank you, Lynn. Well, when I proposed the topic of this talk, I obviously had no idea what a maelstrom the confirmation of Brett Kavanaugh would be. And as you know, I'm focusing my talk on the topic at hand, the ways in which trading Justice Kennedy for Justice Kavanaugh might impact religious liberty. But I want to acknowledge at the outset that the confirmation process has been and continues to be deeply painful for many people, including many people here at Yale. And so when we have a discussion period, I certainly will welcome your reflections on that topic or any others that we've brought up in the introduction as well. Well, let me just begin. Showing up at a spouse's workplace normally does not cause much of a stir. Mary Davis Kennedy's visit to her husband's workplace on the morning of June 27, 2018 was a little bit different. Mary Kennedy's husband is Anthony McLeod Kennedy, who served at the time as an Associate Justice of the United States Supreme Court. And when Mrs. Kennedy and some of her family members came into the courtroom that morning, things started bubbling and stirring in the courtroom, because sometimes a spouse will show up of a Supreme Court justice when they have, especially when they have an opinion to announce. But Justice Kennedy had no opinion to announce that morning, and there was lots of speculation about whether he would continue on the court or retire. And there was speculation that he might announce if he was going to retire from the bench that morning. So you can imagine the journalists sitting on one side, the lawyers in there, Mrs. Kennedy and family walks in, and everybody sits up straight and starts wondering what's going to happen that day. Well, as it turned out, as I just mentioned, Kennedy did not have any opinion to announce that morning from the bench, but later that afternoon, he did announce his retirement from the United States Supreme Court. And he had been there for 30 years after President Ronald Reagan nominated him to serve. Well, after the announcement, President Trump moved quickly to nominate then Judge Brett Kavanaugh to replace Justice Kennedy on the Supreme Court. And the White House sent out a press release talking about this nomination being part of President Trump's efforts to, quote, reshape the judiciary. And the White House said, and I'm quoting here, that this nomination went hand in hand with the president's program to reduce the size and scope of government, which includes many things, including promoting individual liberties and religious freedoms, unquote. Well, to make a very long story short, on October 6, 2018, as you know, the United States Senate confirmed Kavanaugh to serve as an Associate Justice of the Supreme Court by a vote of 50 to 48. And Kavanaugh was sworn in later that same day. Now, especially since the retirement of Justice Sandra Day O'Connor in 2006, Justice Kennedy has been known as the swing justice. A swing justice is a justice whose vote often is decisive in closely divided cases, and who is appointed by the president of one party, but sometimes swings over and votes with the justices who have been appointed by president of another party. So Justice Kennedy has been that swing justice for many years, like Justice O'Connor was before him. Justice Kavanaugh's record, however, suggests that he is unlikely to be a swing justice. Thus, Justice Kennedy's resignation from the court and the replacement of him by Justice Kavanaugh may change American law in numerous ways, including the law of religious freedom. Now, what do I mean when I say the law of religious freedom? I mean the religious liberty guarantees of our laws and how the courts have interpreted and applied those guarantees according to their various judicial philosophies. Most prominently, these would include the constitutional guarantees of religious liberty, and there are 3 of them in our Constitution, one in the body of the Constitution. Article 6, what's known as the No Religious Test Clause. It prohibits the government from placing religious tests on public office, which was quite a revolutionary thing to do when we did that years ago with the framing of the Constitution. Then we have the 2 religion clauses of the First Amendment. And as you know, the First Amendment says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. That first clause is often called the Establishment Clause or the No Establishment Clause. And the second clause, the Free Exercise Clause. Now, just to put it in a nutshell, the Establishment Clause prohibits the government from advancing or denigrating religion or from preferring one religion over another, Baptist over Buddhist, Mormons over Methodists. Can't do that. The Free Exercise Clause prohibits the government from targeting religion for poor treatment. So and regulation has to apply to similar activities, whether they're religiously motivated or not. The government can't be looking to try to penalize religious activities under the First Amendment. So this afternoon, we're considering, again, what trading that swing justice, Justice Kennedy, might mean for trading him for Justice Kavanaugh. And of course, we only have limited data to go on, right? We have maybe the tip of the iceberg, some stuff in his record. He served in the White House, so we have some of his emails discussing these issues from the White House. We have some of his amicus briefs, friend of the court briefs that he filed with the court when he was in private practice, that he then commented on during his confirmation hearings. And we also have his record as a DC Circuit judge, a federal appellate judge. And there are some clues here that we'll talk about, but we need to keep in mind that it's a limited picture that we have. There's much that we don't know. And of course, we won't know how Justice Kavanaugh is going to vote until he votes, right? So it's necessarily speculative, the conversation that we're having today. But it's really important, I think, because religious freedom issues, including the separation of church and state, are principles that have been foundational to our country. And they continue to be foundational today, even as the country changes and our religious demographics change. Especially as we become more diverse, it becomes even more important that we learn to live together across our differences. And of course, religious liberty is one of the ways in which we do so. Also, we can consider and try to make sense now of some ways in which Kavanaugh's record both aligns with and differs from Kennedy's record, and then, try to surmise what that might mean. And always, looking at Kavanaugh's record, knowing that it's limited, and it's also some of it reflecting him being a DC Circuit judge following the precedent as he was bound to do of the Supreme Court. Well, where Kennedy and Kavanaugh differ, it's obviously an important area to look at, right? Because some of the most important church-state cases are decided by one vote. And now that vote is no longer Justice Kennedy's, but Justice Kavanaugh's. But even where Kennedy and Kavanaugh align, or roughly so, it's still important to look at those areas for several reasons. One is that 12 years ago, Justice Samuel Alito replaced Justice O'Connor on the court. And until, she was the swing justice up until the time she left. And Alito's philosophy on church-state issues is significantly different than O'Connor's. So if we're looking at some precedent where O'Connor was in the majority, we certainly can't assume that Justice Alito is going to occupy that same space. It may be a different situation, and then make Justice Kavanaugh's vote play the pivotal role if it's a 5-4 ruling, for example. Also, you probably know that while it only takes 4 justices to agree to hear a case, 4 justices have to raise their hand and say, we want to hear this case. It takes 5 to win, right? So 4 justices usually will not vote to hear a case unless they know they got 5. So when the justices are doing that and considering a swing justice like Kennedy, I think there are probably times, although this is not a public matter, I think there are times when they wondered, could we count on him to be on our side? If we can't, maybe we ought to not take this case right now because we can't be confident of a win. So it may change the kinds of cases that the court accepts because Justice Kavanaugh is less likely to be a swing justice. Also, when a justice is writing a majority opinion, it's very important when there's swing justice to try to hold on to that swing justice, particularly if they're the fifth vote. You want to write it in a way that's not going to lose your court majority. But if the justice is on your side and it's a lock, then you probably write the opinion more expansively. Now, Justice Roberts kind of rides herd on that sometimes, but you're probably inclined to write it more expansively when you know you've got somebody really solidly on your side. And then finally, another reason why it's important to consider even where Justice Kennedy and Kavanaugh are in the same ballpark is because there are lots of different legal tests that the court uses, most of which I'm not going to bore you with today. You'll be very glad to know. What tests the court uses can make a difference in how the court decides an issue. So what Justice Kavanaugh embraces will be very important to watch. So with that introduction, let's look at a few ways in which Kennedy and Kavanaugh compare on certain religious freedom issues, with the first issue being government neutrality among religions. This is the issue I'm referring to earlier about the difference between making sure that the government is neutral toward Baptists, Buddhists, Mormons, Methodists, and Muslims. Well, like Justice Kennedy, Justice Kavanaugh recognizes the basic constitutional principle that the government must be neutral among religions. And this has been recognized for a very long time as being an absolute bedrock principle of the Constitution. In his writings and during his confirmation hearings, for example, Kavanaugh repeatedly said that we are all equally American, no matter our religious affiliation or lack thereof. And he has had some practice, again, a pro bono practice at his firm, where he has defended the rights, taken on cases to defend the rights of Christians and also Jewish people from discrimination, for example. And during his confirmation hearings, Justice Kavanaugh, then judge, made a point of bringing up a particular Supreme Court case that protected the free exercise rights of Muslims. So I think we see a thread there of honoring this basic principle. Unlike Kennedy, however, Kavanaugh seems less sensitive to the possibility that certain governmental actions might have the effect of creating de facto preferences for some religions over another. And that leads me to the second issue. The second issue I'd like to talk about is government-sponsored religious expression in our public schools. Now, this may be the area where there is the most striking and significant difference between Justice Kennedy and Justice Kavanaugh, at least that has surfaced so far. And again, I'm talking about government-sponsored religion within the public schools. Well, I'm going to take a case so we can get our mind wrapped around what this means. The case is Santa Fe Independent School District versus Doe, which was decided by the court in the year 2000. Now, by way of disclosure, I filed an amicus brief in this case, so I want to make sure to get that out. I filed it on behalf of the Baptist Joint Committee, for whom I worked at the time, on behalf of the challengers of the school-sponsored prayer policy. So let's start with some of the facts. Prior to 1995, the public high school in Santa Fe, Texas, had a policy whereby a student council chaplain, they had such a thing, delivered a prayer over the PA system before varsity football games. Now, this practice and others were challenged under the First Amendment's Establishment Clause, saying government cannot organize and promote religion in this way in our nation's public schools. And the challengers, interestingly, were two sets of current or former students and their respective families. One family was a member of the Church of Jesus Christ of Latter-day Saints, otherwise known as Mormons, and the other family was Catholic. So it's important to remember that sometimes religious minorities, they're minorities within the Christian faith also, and they were having trouble with this school-sponsored religious practice because their beliefs were not in line with the kinds of prayers that were being offered. Now, these families asked to sue the school anonymously. Why did they do that? They had been subject to a lot of hostility in the school because of their objections to school-sponsored religious practices, and they did not want to take it on the chin again or have their students take it when they brought suit, as you can imagine, that backlash growing. So the courts permitted, they sometimes permit, as you know, the people to sue anonymously, and they did in this case. And while the challengers were permitted to sue anonymously, a lower court noted at one time that, and I'm quoting here, many school officials apparently neither agreed with nor particularly respected that decision. And the court warned the school and others who were taking the side of the school. They said, we're going to slap you with a contempt sanction or criminal liability if you continue to attempt to ferret out who these challengers are. So I'm trying to lay a little bit of groundwork to understand the context for the case. Well, I talked about the school chaplain prayer policy. After the litigation began, the school revised the student chaplain policy, and the tweaked policy was called prayer at football games. That was the name of the policy. And it called for a student election to be organized at the school about whether invocations should be delivered, and if so, who should give them. Now, subsequently, we're going through the litigation, and I think there's a signal to the school that they may be on uncertain ground with their policy, so they tweaked it again, and they deleted the word prayer from the title of the policy and referred to messages and statements as well as invocations. So it was that latter policy that came before the Supreme Court. So under this policy, students were the speakers of the prayers, but the school was the organizer. They organized the election, they organized the PA system and the games and the program, pre-game ceremonies for the program, for the football game. So the Santa Fe case, therefore, tested a First Amendment rule the Supreme Court had articulated in earlier cases, and I'm going to quote it here. There is a crucial difference, the court says, between government speech endorsing religion, which the Establishment Clause forbids, and private speech endorsing religion, which the Free Speech and Free Exercise Clauses protect. So we got to figure out, which is this? Is this government-endorsed speech that should be invalidated? Or is it private student speech that should be protected? Because both of these things are really important to all of us, right? We want to have our right to express our faith, but also to ensure that the government is neutral on these matters. And I should emphasize that when the court says private speech, that doesn't mean speech in private. It means speech that's attributable to non-governmental organizations or speakers. Other speakers. So the court has long recognized that even when a student is the speaker, that speech can sometimes be school-sponsored speech because of all the indicia of support that I mentioned earlier. But let me give an even more obvious example, school-sponsored prayer. If I'm the teacher, I call on a student to pray. I've selected who's going to pray. I have organized the prayer, and I'm holding people captive to hear it in the classroom. So that's obviously school-sponsored prayer, even though the student is offering the prayer. It's coming out of the mouth of the student. Now, the court has been especially attentive to government pressure in the public school setting, because why? We have impressionable children, not adults. And they're there not because they want to be, although some of them I sure do, but they're required to go to school, right? So the court has been really careful about prayer in that context. Legislative prayers, for example, are treated differently by the court. So put that in another box. Well, why does the Constitution prohibit government speech endorsing religion, including school-sponsored prayer? And put simply, it's because the First Amendment, we believe, has said that it isn't the place of government to promote religion or organize religious exercises. That is the right of individuals, not the government. Well, back to the Santa Fe case. In a 6-3 decision written by Justice John Paul Stevens, the Supreme Court held that the Santa Fe policy was school-sponsored prayer and thus invalidated it. Again, it was a 6-3 decision with Justices Kennedy, O'Connor, Souter, Ginsburg, and Breyer joining Justice Stevens' opinion. And the court said that the policy was invalid on its face. It said, viewed in its overall context, and here I'm quoting, it established an improper majoritarian election on religion. You remember the West Virginia versus Barnett decision about saying, our rights, our precious individual liberties aren't up for an election. They're held in sacred trust for everybody, no matter if they're the member of the most popular group in the nation or the least popular group in the nation. So going on, the court said the school had established an improper majoritarian election on religion and had unquestionably had the purpose and created the perception of encouraging the delivery of prayer at a series of important school events. And the decision cited the fact that the schools were over the public address system by a speaker representing the student body under this election that had been organized by the school, under the supervision of the school faculty, and pursuant to this school policy that by its context looked like it was implicitly and explicitly encouraging public prayer. It also noted that some band students had to go to the game. It wasn't something that they could miss. The football team had to come, cheerleaders had to come, so it wasn't just an option for all the students. Some students were required to be there. And the court's opinion relied in part on an earlier ruling written by Justice Kennedy, Lee versus Weisman in 1995, declaring that public schools could not invite clergy to offer prayers at graduation. So we see Justice Kennedy playing an important role in creating a building block that the court used and Kennedy affirmed in the Santa Fe decision. Now, very importantly, at the same time, the court pointed out that nothing in the Constitution, as interpreted by this court, prohibits any public school student from voluntarily praying at any time before, during, or after the school day. The court wanted to be very clear about that. And that's absolutely right and should always be protected. Indeed, there are many other ways for students to express their faith at school. And if you're interested, we can talk more about that a little bit later. I've worked on that issue quite a bit, and it's important for us to protect those rights. Well, as it happened, I attended an event the afternoon when Santa Fe decision was handed down where Justice O'Connor was speaking. And I had the rare opportunity to have a few words with her. So I had filed a brief on behalf of the challenger, so I agreed with the decision that she had made and the other 5 justices, and so I congratulated her on the decision. And when I did, Justice O'Connor looked at me, and with her characteristic dry humor, she said, "The decision is not universally admired." I assumed she had been hearing some things about the reaction, including from Texas, about that decision. Well, as it turns out, Brett Kavanaugh is one of those, and was at the time, I believe, who is not an admirer of the Santa Fe decision. And I say that because Kavanaugh appears to believe that the court, the Santa Fe court, got the meaning of the First Amendment wrong. Kavanaugh, who was then an attorney in private practice, wrote an amicus brief, again, a friend of the court brief, for then Congressman Steve Largent and J.C. Watts, asking the court to uphold the Santa Fe policy. In the brief, Kavanaugh argued that the school's policy was religiously neutral. It did not require or encourage prayer, he said, and it was simply private student speech, the kind that it should be protected. And he even suggested that not only was allowing prayers in this setting constitutional, but it would be unconstitutional not to allow those prayers, to silence them in this setting. And Kavanaugh made a prediction in his brief. He said, "There should be no mistake then about what's at stake here. If the theory advanced by the challengers is to become enshrined in this court's case law, the full extermination of private religious speech from the public schools would be well on its way," unquote. 18 years later, I think it's safe to say that this prediction was wrong. Religious expression, and I have some experience dealing with this, and I think many of you may too, is alive and well in our nation's public schools. Well, during Kavanaugh's confirmation hearing, Senator Cornyn from Texas brought up the Santa Fe case. And interestingly, Senator Cornyn was the Attorney General of Texas at the time that the Santa Fe case was argued. So he, too, was unhappy about the Santa Fe decision, and he complained about it. In fact, he said it stuck in his craw. And he pointed to the dissent and said, that was the right, they had the right view of the Constitution. And Cornyn marveled at the fact that Americans, can't speak about religion in a public forum, is what he said. Now, Kavanaugh made no attempt to defend the Santa Fe ruling, but he did gently correct Cornyn's incorrect assertion about individuals not being allowed to speak about religion in a public forum. He pointed to cases that did allow that. So here we have a plain difference between the judicial philosophies, I think, of Kennedy and Kavanaugh. And my strong sense is that if a case like the Santa Fe case came before the court with Justice Kavanaugh on it, a case like that comes up, that it would come out a different way, both because Kennedy has now been traded for Kavanaugh and because O'Connor was earlier traded for Alito, if you will. Well, now let's move beyond the public school context. I've been talking solely about public schools up till now in terms of religious expression. Kennedy and Kavanaugh seem to be largely on the same page regarding government's role in religious expression beyond the public schools. both seem to read the First Amendment to basically support religious displays or messages that are sponsored by government if they aren't clearly preferring one religion over another, although that can become, dicey when you're looking at Ten Commandments displays, for example, depending on how they're configured. But whereas Kennedy was often in dissent on such rulings, the presence of Alito and now Kavanaugh in the court could lead either to the reversal of those decisions or watering them down. Now, since we're talking about the Ten Commandments, I just can't resist telling you a quick story. You may recall that several years ago, more than several years ago, about 10, there were 2 cases pending at the Supreme Court dealing with Ten Commandments displays and whether they were constitutional. And everyone at the time was trying to guess how they would come out. And at the time, Justice O'Connor was the focal point of attention. And so people were thinking about her as a swing justice and thinking about how she often liked to split the difference in cases, come out somewhere in the middle. And this prompted a law professor, Jack Balkin, to confidently predict that Justice O'Connor would strike down 5 of the commandments and uphold the other 5 commandments. Thankfully, Professor Balkin was wrong about that. Yeah, I know. Let me just quickly mention 2 other issues in this ballpark. Like Kennedy, Kavanaugh believes that the Constitution requires the government to give religious individuals and organizations equal access to government property and facilities for their speech. So when a public school opens up its facilities for community use on the weekends or after hours, that religious groups should have the same right as secular groups to come in and use the property. And that's an important way that the court has ensured that religion can play a robust role in public life. And so that's one principle. And I'll just note in passing, if this is in your head ringing, that it has been discussed by some justices on the court, including Justice John Paul Stevens, who tends to be pretty separationist, that when a high-ranking government official talks about their personal religious beliefs, like the president, for example, that we don't rule that unconstitutional. We understand that the president is talking about their own personal faith as well as, serving in this official capacity. So we've been talking so far about religious speech. Let's now switch to talk and government-sponsored religious speech, including some endorsement. What about money? Government financial aid, government subsidized religious activities and messages. Let me just touch on this quickly. In his writings and during his confirmation hearings, Kavanaugh said that the Constitution supports a right for religious people to participate in public programs on an equal basis as non-religious people. So here he means programs of financial aid, as well as other kind of programs. And I think the principle that religious organizations should be able to compete with non-religious organizations on an equal basis for government aid for secular activities is increasingly non-controversial. And let me just give you an example that my friend, Professor John Duilio, the first director of the White House Office of Faith-Based and Neighborhood Partnerships, has said. He said the St. Vincent de Paul Center should not have to change its name to the Mr. Vincent de Paul Center in order to get money for its secular activities. Well, that's the part that's pretty agreeable. Now, there's more complication than that, but I'm going to leave it there for now. So we're talking about government funding, grant program for secular activities, feeding the poor, for example, getting people off welfare and on to work. But this principle also sometimes means, and I think Kavanaugh believes that it means, that the government can or must allow religious groups to use government grant money, for example, to pay for religious activities as well as secular activities. So let me give you an example here. Say a faith-based group aims to get people off drugs by having them read the Bible and participate in worship. Can they get a government grant and use that money to pay for the Bible study and the worship and to weave that into a secular government program? And as I understand Kavanaugh's perspective, his answer is yes. And so here is another, but this is actually a place where Kennedy and Kavanaugh seem to be in the same ballpark, although it does seem that Kavanaugh seems to push a little bit beyond Kennedy as far as I can tell, but I'm certain these issues will come up and we'll hear more from Kavanaugh. Now this perspective, even though Justice Kennedy has been, and Kavanaugh are in the same ballpark, it has been the minority on the court to date with regard to direct funding. There's a difference when we're talking about vouchers, and we can talk about that if you wish later. But this perspective on disallowing government grant money to be used for religious activities has been the majority position, narrowly so because Justice O'Connor swinged over with the more liberal justices and put her foot down there. Now that Alito has replaced O'Connor and Kavanaugh Kennedy, we may have a different result. Finally, just another look at another principle, a free exercise principle. Free exercise is a very important right in our country. It is contentious in some ways today, but at its foundation, continues to bind people together, that everybody ought to be able to practice their faith without unnecessary governmental interference. But let's look at one particular case here, a case that Kavanaugh decided when he was on the DC Circuit Court of Appeals. And the case is called Priests for Life versus the Department of Health and Human Services. And it involved the contraception mandate of the Affordable Care Act, often known as the ACA or Obamacare. You may have heard of this mandate. It generally requires health insurance coverage and employer-sponsored health plans to cover preventive services without cost sharing. And that includes, this is for women, like breastfeeding support and counseling, well-woman visits, mammograms, and contraceptives that are approved by the FDA. And this mandate was very controversial, if you remember, just a few years ago. And the challenge was for the Obama administration to try to accommodate religious objectors to this proposal while still getting to women working for objecting employers the coverage to which they were entitled under federal law. And at the time that Kavanaugh considered this case, agency rules exempted houses of worship from having to provide this coverage because they knew that they might have objections, like Catholic churches. And the rules also accommodated other nonprofit religiously affiliated organizations like religious hospitals and schools. And after the Supreme Court ruled in the Hobby Lobby case, closely held for-profit corporations. These entities didn't have to contract, arrange, or pay for or refer for contraception coverage if they had religious objections, but the federal government still got women working for them the coverage through another means, mainly insurers. So this plan, however, for this religiously affiliated nonprofits, it wasn't good enough for some of them, and they sued over it. And under the Religious Freedom Restoration Act, which is a federal statute, actually not part of the Constitution. And they objected, part of their objection was to filling out the form to actually signal to the government that they wanted the exemption. They said that by doing that, they were becoming complicit in the issuance of the contraception coverage to their employees. Now, the DC Circuit rejected that claim and said, look, we respect your religious beliefs, but it is the law that requires the coverage to go to your employees. It's not your filling out this form. Filling out the form lets us know that you want the exemption, but the law, secular law, requires the coverage to go to your employees. Well, this came before, as I said, the DC Circuit, and it actually got reheard by the entire court, not just a three-judge panel. And Justice Kavanaugh dissented from the ruling of the court. He said that under RFRA, the Religious Freedom Restoration Act, judges must defer to the challenger's religious views, even on these legal issues. In their view, he said, submitting the form is itself an act that contravenes their faith, and thus the court must find that their faith was substantially burdened under the law, which is the first prong of the Religious Freedom Restoration Act. Now, Justice Kennedy's views on this precise issue are not clear because he didn't have to squarely face it. So we don't know exactly how they compare. But why is this issue important? Because, as I said at the top, religious exemptions are a very important issue to many people. They're controversial in some settings, including when they have to do with women's reproductive rights. And so the court will, I think, undoubtedly decide decisions about religious exemptions. So Kavanaugh's views may really matter on these decisions. So I've noted where Kavanaugh's positions, some of them compare to Kennedy's, and some places where he breaks with Supreme Court precedent. Let me just close by offering a few thoughts of my own about, respectfully, what I think Kavanaugh gets right and wrong about the Constitution. I think Kavanaugh gets the Constitution right when he says that the government should not prefer one faith over another. I also appreciate the comments he made at his confirmation hearing about looking for win-win solutions when we have competing human rights. So how can we, get the coverage to the women that wanted of contraception coverage while also honoring religious objections? Although I differ with his analysis on the case that I mentioned, his specific analysis. Also, during his confirmation hearing, Kavanaugh said, and I quote, he was he was quoting Justice Kennedy from the Masterpiece Cake Shop decision. Kavanaugh said, saying the days of treating gay and lesbian Americans or gay and lesbian couples as second-class citizens or inferior in dignity or worth are over in the Supreme Court. Kavanaugh added, that's a very important statement, and I'm glad he said that. I also think Kavanaugh gets the Constitution right when he says that the Constitution generally requires the government to give religious groups equal access to government property and facilities for their speech. Respectfully, however, I think Kavanaugh gets the Constitution wrong on some other points. In my view, government-sponsored religious messages, as well as government-funded religious activities, are basically unconstitutional. They harm both freedom and faith, in my view. Governmental speech endorsing religion violates the conscience of every American by taking a position on religious matters, something that the government's not supposed to do. Such speech also violates the command of neutrality among faiths, I would argue, because when the government sponsors religion, it always picks and chooses, right? It doesn't sponsor them all equally. Usually the majority faith is preferred and other faiths are discriminated against. And this creates not de jure by law preferences, but de facto preferences, depending on where you live in the country. If you live in Texas, it may be evangelical Christians. If you live in Utah, it may be the LDS Church. If you live in some parts of New York, it may be something else. Well, so I believe that not only does the government do something to violate everyone's conscience when it backs faith, if you will, and not only do the faiths that don't receive the government's backing suffer because they're discriminated against, but I also believe that the religion the government supports also suffers. I can't say it better than my ancestor Baptist pastor John Leland did back in 1804. Pastor Leland said, and I'm quoting here, "Experience, the best teacher, has informed us that the fondness of magistrates to foster Christianity has done it more harm than all the persecutions ever did." And he ought to know. "Persecution like a lion," he said, "tears the saints to death, but leaves Christianity pure. State establishment of religion like a bear hugs the saints, but corrupts Christianity and reduces it to the level of state policy. In short, in my view, government support for religion warps faith and robs it of its prophetic power to stand independent from the government and to challenge the government from a position of independence and non-subservience and non-corruption, I would say. Also, what the government funds, it regulates, even if what it funds is religious. And depending on the city or town, government subsidies for certain sacred texts are going to generate fierce political opposition. It's just going to happen. So in short, I think if the court breaks with precedent in these ways, it will violate the rights of conscience, invite government meddling in faith, and result in de facto preferences for some faiths over others. And finally, while I very much agree with Kavanaugh, the exercise of one's faith is a robust right under the Religious Freedom Restoration Act, I think that he has the precedent of the Supreme Court wrong and Congress's intent with RFRA wrong in its interpretation of the substantial burden test. Certainly, religious beliefs should be given significant deference, but I think it's a mistake to say that anything that seems like a burden to a religious person should necessarily be deemed a substantial burden under law. Legal judgments, I think, can and should continue to be made by the court. Now, to be sure, courts shouldn't attempt to determine whether a law imposes substantial religious cost. Then it's going to get in areas of saying, is this religion plausible? Is it rational? How much cost is this religiously? That should be off limits under the Constitution. But courts can and should determine whether the law imposes a substantial burden on religious exercise as a legal matter. And courts can do so by relying on secular law, including Supreme Court precedent. And I believe religious exemptions are valuable and often needed, but I'm also concerned about cases that would improperly use free exercise claims to blow gaping holes in our nation's treasured civil rights laws. So I think there should be a balancing test for religious exercise and competing interests and claims, but not a blank check. We need to have that healthy balance of competing interests. So let me just close by quoting another swing justice, Justice Sandra Day O'Connor. I didn't agree with her about everything, but I always respected her. And I especially appreciated what was her swan song at the Supreme Court, her final opinion on the court that was on church-state issues. And so I'm going to read you a passage from her swan song opinion. Justice O'Connor said, "Reasonable minds can disagree about how to apply the religion clauses in a given case, but the goal of the clauses is clear: to carry out the founders' plan of preserving religious liberty to the fullest extent possible in a pluralistic society. By enforcing the clauses, we have kept religion a matter for individual conscience, not for the prosecutor or bureaucrat. At a time when we see around the world the violent consequences of the assumption of religious authority by government, Americans may count themselves fortunate. Our regard for constitutional boundaries has protected us from similar travails while allowing private religious expression and exercise to flourish. Americans attend their places of worship more often than do citizens of other developed nations and describe religion as playing an especially important role in their lives. Those who would renegotiate the boundaries between church and state must therefore answer a difficult question," O'Connor said. "Why would we trade a system that has served us so well for one that has served others so poorly?" End of quote. In my view, Americans should not trade the system that has served us so well. Instead, Americans should work diligently to keep it. Thank you.
Identify yourself when Melissa calls on you, and would you disguise your comments as a question? Please. There are going to be lots of questions, so be succinct if you would, and pose your questions. So,
great.
Here we go.
Let's see, I saw this gentleman right behind you, and then we'll come to you again.
You're quoted in the last issue of Church and State regarding this evangelical advisory council.
Oh, am I? Okay. What did I say?
Fundamentalists get such power to determine public policy, including policy regarding religious freedom. And what, if anything, can be done about it?
Okay, so thank you for that question. So the gentleman is referring to what is sometimes described by the Trump administration as an unofficial evangelical advisory board, although sometimes it seems to be official, but then most times they call it unofficial. And it apparently was organized during the campaign and has carried over in some form or fashion into the administration. And I really can't tell you, I don't have much visibility into the administration about how that group operates or what they do. So Americans United has an advocacy group on separation of church and state and religious freedom, has asked for transparency about that group. And you know, I have registered concern about it, both about lack of transparency, because we also, during the Obama administration, had an advisory group, but it was people of all faiths and none were represented, or as broadly as we could, in a 25-member group that rotated 3 times. But we were subject to and tried to make all our reports transparent and our meetings transparent, our calls, so people could come and participate, and I think that's the way it should be. And also, I think that is problematic, even unofficially, from at least an appearance point of view, if you have a body connected to the administration that's only for members of, you know, one subset of one faith. That just, you know, that does not send a good signal. So I think what's happening there is they've requested that there be some more transparency, and we'll see whether that happens.
I'm sorry, Greg, I never said my name. Barney Case in class of 56. I helped to organize the National Council on Religion and Public Education.
Oh, wow. Super. Well, thank you. Absolutely. A valued colleague. You all did yeoman's work, and we are still profiting from your work in those early days. So thank you. Thank you so much. Let's see, here and then back there. Yeah, go ahead.
I'm Dick Stadesny, class of 1952. Do you think Chief Justice Roberts may err toward the left to prevent the Supreme Court looking like an arm of the Republican Party?
Yeah, great question. I hope everybody could hear it. So you have a nice loud voice. So, you know, I think that there's no doubt in my view that he is, you know, a fairly conservative. These labels don't always map well to the court, but that he comes from a perspective that probably would have more in common with Kavanaugh than not. But I think that he is very dedicated to the court as an institution and to its perception as being, a body in Washington that is not about politics. So I don't know if you caught earlier this week, he did a talk at somewhere in Minnesota, I believe. And, he doesn't do that many talks. And he was out in the public at a university, he was in a judicial conference, stressing the need for the court to be independent and to continue always with its independence. So I don't know that he will necessarily become a swing justice, but that's not the only way to try to get at some of these dynamics. You can get at it in part by deciding which cases you take and which you don't. Maybe some more divisive cases you don't take, ones you know. I mean, they're going to take some, but maybe not very many. And then it can be a kind of governor switch, like how many do you take? During how many a term? And so I think, with some variations, I definitely disagree with the chief on some cases, think he's gone wrong on some important cases, but I respect the fact that he is dedicated to the court as an institution and has the intention of trying to keep it above politics. Now, we'll see how successful he is.
He did it with Obamacare.
Yes. Yeah, I mean, that's an example. So thank you. It's an excellent question, yeah.
Loring Brazil, second year MAR, 2019, eliminating school. I apologize if I'm a little bit later. But I was just wondering, how do you see Kavanaugh ruling, I guess, perhaps with the Smith case?
Yeah.
Do you see that as just precedent? And it seems that the court has kind of transferred a little bit of the free exercise into the free speech clause, making it like a substantive free speech.
Now, are you in the law school or the div school? You sound like a lawyer.
So how do you kind of see how the development is going? It just seems that at times they're almost like trying to prefer a specific religion, but just doing it through a different clause when they kill another one.
Right. So the employment, we're referring to the Employment Division versus Smith case, which was decided in 1990. And I didn't go into this in my talk, but I'll do the very quick version here. The court before 1990 had largely, I'm using some weasel words here because it's more complicated, had applied a very rigorous test, a compelling interest test, to free exercise claims prior to 1990 and said, it doesn't matter if the government's trying to target religion, even if it, does so by inattention, tells a Jewish boy he can't wear, there's a no hat rule at public school, so the Jewish boy gets hit by that because he wears a yarmulke, and they're just trying to get rid of baseball caps. So what test gets used? And now, when the compelling interest test was used, that Jewish boy was in much better standing and luck. Then afterwards, the Employment Division for Smith, authored by Justice Antonin Scalia, interestingly, said, no, we're not doing that compelling interest test anymore. It makes everybody a law unto themselves on religion. We're not doing that. We can't do it in such a diverse country, at least as a matter of what the First Amendment requires. And so we're just going to look and see, does the government target religion? Is it regulating religious activities when it's not regulating similar secular activities? So it was a much lower standard of protection for free exercise, and one which I think is actually wrong. But so there was the reaction to that, and that's how the Religious Freedom Restoration Act got passed that I just talked about. But of course, there are some controversies there too today. So will the court vote to overturn Smith? It's a very interesting question, and I don't think Kavanaugh has necessarily tipped his hand on this. He's been very stout about interpreting the Religious Freedom Restoration Act and also the Free Speech Clause, as you say, to do some of that work that he probably would have done under the Free Exercise Clause. But interestingly, and now I'm blanking on which case it was, but I believe it was Justice Gorsuch in one of the opinions from the last term, referenced the fact that Smith continues to be controversial in some quarters, and we know that Alito, has some, reservations about it too. So that could happen, but I would think in part, my guess, and this is just a guess because of if that were to be where the justices, 5 of them or more, might come out as a matter of interpretation of the First Amendment, that might be something that Chief Justice Roberts might not want to put on the plate right away, even if they do have the 5 to go in that direction. That's just some guesswork there. Others? Let's see. Did I see a hand go up? Yes, please.
This is a little off topic, so you can ignore it if you like, but I'm curious to hear your perspective. My sister was the lead plaintiff in taking the state of Texas to the Supreme Court when they closed her women's clinics along.
Oh, wow.
So June 2017.
Hmm.
And I look at all the changes on the Supreme Court since June of 2017. And it's not, I imagine this isn't an issue that comes right into your realm.
No, thankfully so.
I thought if it did, you could just comment, and I'd be interested in what you think about it.
Yeah. Well, it's an interesting, I'm glad to know that you've had such a close experience with the law, because not everybody is a named plaintiff in a court case, so that's certainly an interesting experience to have in your family. The point where I deal with these issues in my work is mostly in the free exercise realm, in terms of people objecting to abortion, not wanting to have participation with that. Then how can the free exercise protect them so that they don't have to participate in it? And it's a different question about what state policy should be. Yeah, thanks. I'm sorry. Yeah, Pamela.
Pamela Yatunde. I teach at United Theological Seminary in the Twin Cities. And you talked about the balancing test, and I'm wondering if you think that Justice Kennedy avoided any test whatsoever in the masterpiece case shop. And with that, do you agree with his assessment that the Civil Rights Commission was actually hostile towards?
Yeah. So Pamela brings up the Masterpiece Cake Shop case, which most of you have probably heard of, that was heard last term, that dealt with a civil rights law in Colorado, a state civil rights law that applies to public accommodations, including retail businesses, including this cake shop owned by Jack Phillips, who objected for religious reasons to complying with the civil rights measure. And let me back up and say why. The civil rights measure says that all public accommodations have to be equally open to people, and there can be no discrimination based on, among other things, sexual orientation. So a couple comes in and says, we'd like to buy a wedding cake, and they start to talk about the cake and find out that the cake is for 2 men. And then Jack Phillips says, I'm sorry, I can't. I'll sell you brownies or other things in the store, but I won't sell you a wedding cake because of my religious beliefs. They leave. They sue Phillips for violation of the Colorado Anti-Discrimination Act. Jack Phillips defends by saying the First Amendment's free exercise and free speech clauses mean that I know that there's that state law there, but the Constitution's Trump state law, and I should be exempted from that state law along with my bakery that I own because of my religious and free expression beliefs. It was both of those things, as you recall. And there was no, that was how the case was litigated, on the basis of the First Amendment's free speech and free exercise clause. So the court ended up ruling narrowly in favor of in favor of Jack Phillips and his bakery. And now I say narrowly, I mean on the merits, because they did not decide the question about whether in another case a bakery like this might get an exemption, although they, in some of the opinion, they were pretty stout about saying that there needs to be non-discrimination. That's been the presumption, and that's what we've honored through the years. So they put some markers down there. But what they found instead, as Pamela suggests, was some comments by commissioners on the State Civil Rights Commission who had adjudicated the claim at a lower stage and had said things like, I won't get it exactly right, but it's something about, religion has been responsible for ills over the years, including the Holocaust and these other things. And so there, Kennedy and other justices indicated that there was some hostility shown to religion because they were the adjudicators making these statements. And then there were some elements, and I won't go into it because we don't have time, but there were some elements of possible different treatment of bakeries that had objected to putting anti-same-sex marriage messages on cakes and ones that had objected to putting cakes for same-sex marriages. So, you know, I think that I can see where that comment was not, you know, not neutral, not the way that a person should handle it on the Civil Rights Commission. We shouldn't be in government passing judgment on saying your religion is bad, or I presume that it's in bad faith, it's insincere, and there were elements of that in the comments. So I think that's the wrong place for government to be. Now, that doesn't mean that government grants all the exemptions, including the exemption in this case, which will be litigated in another case, but rather that they say the government should do is, look, the law applies in this way, and because it applies in this way, you don't have an exemption, but steer way clear of making comments evaluating somebody's faith or disparaging somebody's faith. So that's where I come out.